All right, this question came in today, which is, can I start talking about my invention before I file for a patent? Hi, everybody. I'm JD Houvener, owner, founder here at Bold Patents Law Firm, also a patent attorney. I've helped inventors for over 10 years achieve over 500 patents as of today. I'm also the author of Bold Ideas, the Inventor's Guide to Patents. I'm excited to talk with you about this question about pre-filing disclosures and talking about third parties about your treasured invention. So how much should you talk about, if at all, with third parties? Now, this is a really tough one. I like to say, don't share anything publicly until you filed a patent application. Okay, that is the best solid advice I can give. Now, there are reasons why you might need to disclose and talk about your invention to third parties before filing. One might be you haven't actually invented or completed the invention process. You need help from a technical standpoint, and you need a co-inventor to come in and help you solve the problem you're trying to achieve. If you need help in that regard with respect to the actual invention, finding a co-inventor, someone who actually can help confirm that this invention will do what you think it will do, that may be a good reason. So working with another person, individual, having a non-disclosure agreement put in place between the both of you so that no one's worried about one disclosing to publicly without filing first is important. So working with a business attorney to draft contract between the two of you would be the safest way to go. If you're going to be working just more on arm's length and really making sure you have the best position possible, that's my advice. Now, there may be another reason where you might want to talk or share with another party before filing an application. And that could be just in terms of how much money can you raise? How much money do you need to develop in order to prototype this product? Maybe you need to talk with a business individual, a co-founder, to learn about what's possible in terms of the market, do the research and diligence that's needed to find out if this invention is worth filing, meaning investing thousands of dollars and lots of time and effort going down the path to get there. If you truly have no funding, you might need to reach out to another person to have them put in their money or help them put the business plan together with you before filing. Again, my number one advice here is to, if at all possible, work with a patent attorney and get your invention filed before publicly announcing or discussing your invention. But those two reasons are kind of the ones that do come around, and they can provide some reason or basis for you to want to proceed with talking to third parties, individuals before filing. There is a rule in the United States that there's a 1-year timeline from when you have a public disclosure. Let's say you have talked or shared your invention with someone in the public, taken it to a trade show, put it up online, started offering your product for sale. There's 1 year from when you start publicly disclosing, when you must file a patent application. If more than a year goes by, your patent application and patent, if it does issue, could be invalidated because you waited too long, and that 1-year statutory bar will prevent you from enforcing your patent rights. So don't make that mistake. Get ahead of this, work with a patent attorney, talk about what you need to do to file the application to get that patent pending status, and therefore you can start discussing, talking to third parties, co-inventors, investors, and business partners. All right, everybody, hope this was helpful for you. Have a great rest of your day today. Go big, go bold.